Thanks for joining us here at WBZ along with David Wade. We are in the second full day of deliberations in the Karen Read trial. We want to go to the courtroom. We're told the jury has a question for the court.
We can see everyone filing in right now, including, of course, the defendant, Karen Read. It looks like they're walking up to the judge for perhaps a sidebar before we hear what this question is. But of course, all eyes have been on this trial for a very long time. This is the second time around. The jury got the deliberations on Friday afternoon at about 3 o'clock, had a very short time on Friday, but then had a full day, Paula, yesterday. We didn't hear from them, but now they're back, and they have a question pretty early here in the morning.
No questions at all yesterday, and this is interesting. It was day 2 of the first trial when the jury requested the CERT team report and had their first question. This morning, our Christina Rex, who of course is in the courtroom, said the jury indicated they had a question by giving a note to the judge. All of the lawyers get to read that note as well, and now they are filing back into the courtroom to gather, decide what the question is, and give it to the court.
Let's bring in Cheryl Fiandaca, our chief investigator, also a lawyer. And Cheryl, obviously, we have no idea what they might be asking. As Paula just mentioned, last time their first question was looking for a specific report, something to do with evidence. The judge basically said, you have all the evidence in front of you, you have to use that. We have no idea what they're about to ask. Any thought on this?
Well, it could be anything. It could be about the evidence. It could be a question of law that they have about any of the specific charges that they're asking, whether or not this applies to that. You know, you don't know how they're going about the deliberations. Have they gone into deliberations going charge by charge? Have they gone into deliberations discussing evidence, discussing, you know, what they think about credibility, how much weight they need to give it? I mean, those instructions, they went on for quite a while. When she was explaining the law to them, and it's not really that easy to decipher. I mean, the charges are very nuanced, and you know, it's not unusual that they would have a question about that or any of the evidence in an 8.5-week trial.
And it's interesting, everyone's trying to take the temperature of the courtroom, what the jury might be thinking at this point. Christina Rex reports that the jurors reported to the courtroom this morning before they were sent off to deliberate, and she tweeted, overall, they're back in more normal clothes that they typically wear, not loungewear as they appeared to be in yesterday, expecting a long day ahead. Does that give you any indication of what they might be thinking?
You know, that's so interesting. You know, it's hard to read the tea leaves, right?
Yeah.
I mean, you don't know whether or not that has anything to do with anything, or whether they came in today saying, you know, we think we're close to a decision and we expect to be able to come to a verdict, or whether they're not able to come to a verdict and they want to say to the judge, you know, what do we do in a situation where we're kind of, seems like everyone's dug into their position. So we can listen in now here.
Yeah, so everyone's going back to their positions. We should hear from now Judge Beverly Cannoni about what that question may be, and we'll get a better sense of where they are perhaps in this process.
Bob, I can't do this. I can't do this.
We're going to let this try to breathe as much as we can so we get a real sense of what's happening in the courtroom. But while Karen Read is talking to members of her defense team, it will be interesting, Paula and Cheryl, because this first question should give us an indication of whether or not they're still diving into the testimony and the evidence, whether it's a question about that, or whether they're at the point where they'll now start having some questions about the 3 different possible verdicts, and whether or not they're looking for perhaps an explanation of wording, especially on the manslaughter charge. There are so many different options of things you can check. So it feels like this will be an opportunity to get a sense of how far along in the process they might be.
And hundreds of pages of documents, Cheryl, of course, that they're going through. I see Karen Read conferring here with her attorneys. We said just a few moments ago, the note from the jurors to the judge that they have a question is also read by all of the attorneys involved. So they're clearly aware of what direction the jury is heading in, into what they want to know this morning.
Right, what they wanted to know. I mean, it could be something as simple as asking for a piece of evidence or asking, about something that happened during the trial that they want the judge to clarify. It could be something much more complicated, like you said. Some of these charges, have a lot to them. There are a lot of elements to each of these crimes that she's charged with, and deciphering all of that based on the evidence, based on the credibility, based on what they believed during the course of this trial is a lot to ask for a group.
Just want to give you a quick sense of what's happening in the courtroom, because Christina Rex, who has been on this trial since moment one, and as soon as we hear the judge speak, I'll stop talking, obviously. She says that the jurors are not in the room yet. That was a minute ago. Sidebar is done. David Yannetti, part of the defense team, according to Christina Rex, said something to the Reed family. Someone said, quote, God, and then they all exhaled and act physically relieved. Don't know what that means, but that's what's happening inside the courtroom right now as Christina Rex watches on, and now we see the defense team huddling and going over whatever they may now know about this question, although it's unclear probably, Cheryl. Did they already hear the question when they went to the sidebar, or they still need to wait for the judge to say it aloud?
I presume they already know about it. Usually when they go up to the sidebar, the judge says this is what they're asking about. She's going to bring them in. Sometimes she'll say, I'm going to tell them to go back and continue to work on it. I'm going to tell them they already have all the evidence they need. Whatever she plans to say to whatever their question is, how she plans to answer it. So they're conferring here. The possibility is that they're conferring because they said to the judge they want an opportunity to discuss and come back to her with asking her to say something or do something different from what she planned to do. So we'll see as this all shapes up. But it looks like everyone is gathered in kind of a conference to sort of figure out what they're asking, what they want to know.
She's very involved here in this conversation, and it's interesting because the last thing that we know that they really had an issue with was the actual verdict slip. They thought it was still confusing. We heard from Karen Reed outside of the courthouse yesterday saying we know that it was confusing the first time around, and they want to make sure that it's less confusing this time. There has been no change to the verdict slip since Friday when they first sort of made their objections to the judge. They basically want the manslaughter charge to have a much more clear, almost little box to check off.
Counsel, what I'd like to do is I'm just going to read the questions to you now, so please take your seats. So I'm going to read the questions. I'm going to have them marked. Then I will take a short recess, let you all talk about it, and then come back.
Thank you.
So, all right. So I received 3 questions from the jury. The first one is, they appeared on note cards, so that I don't know what order they came in, but this is the order I got them. This is the order I'm going to read them. What is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The second, are video clips of Karen's interviews evidence? How can we consider them? And the third, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? So I will give you some time to consult. I think the first one, I'll hear from you as to what the time frame is, and I don't need to hear from you now. That's pretty clear cut what they're looking for. The second one are video clips of Karen's interviews evidence. How can we consider them? Well, we know they are evidence and they can give them whatever weight they want. I would also be inclined to give a humane practice instruction, and tell me if you want the digital evidence instruction. It's a little awkward because it would be something like, before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the person who appeared in the communication was in fact Karen Reed. So think about that when I come back out. But I think it's appropriate to give a humane practice instruction. And also tell me what you think about what to say about the weight. The third question is a little bit more, I think, unclear as to exactly what they're looking for. Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What I'm proposing, I gave you both a verdict slip where I included the language. I know yesterday I said they have to be read hand in hand, the jury instructions with the verdict slip. I've incorporated the language from the jury instruction into the verdict slip. I've given each side a copy. When I come out, I'd like your input on whether you think this is appropriate. I would instruct them, as I did before, that they start at the top and work their way down. That's the only thing I did not specifically put in here, but I think it takes it step by step, an analysis to do it. So how much time does the defense want to be able to respond to me?
Perhaps 15 minutes.
Okay. And the Commonwealth?
That will suffice.
Okay. So it's 7 past. Why don't I come out at 25 after, give you 20 minutes?
Thank you, Your Honor.
So 3 questions from the jury, which the judge said were on note cards, so in no particular order. These were just the questions. The first, and Cheryl, let's have you react as we read each one. What is the time frame for the OUI charge, 12:45 or 5 a.m.?
Well, it has to be 12:45 because she's charged with hitting him at 12:45 and driving drunk at 12:45 because at 5 a.m. she wasn't driving. So that's what I presume they'll come back and say. So that one, so it appears that they're zeroing in on the drunk driving aspect of this case, and the fact that they do have blood alcohol evidence that seems to show that when they did take her blood the next day, that it showed that she was over the legal limit. As to whether or not the Commonwealth was able to prove to this jury beyond a reasonable doubt that meant that at 12:45 her blood alcohol level would have been higher, even higher than that.
Than it was. Yeah.
Right. And that's one of the things that it appears that they're concentrating on. I think one of the things that we should probably just be careful of here is that the judge said that this was the question for the second question, which is what we're talking about here on the manslaughter charge, that we're back down to the operating under the influence charge, which is basically back to the same question. But they said, i.e., number 5. So we're not sure that they are concentrating on number 5.
Or just using it as an example.
Using it as an example.
It is interesting, though, and of course, we have to be very careful about jumping the gun on this. But to your point, she said that the one that they used as their example, they said, can you basically say that she's guilty of one of the subcharges? I'm going to hold this up. You're not going to be able to see it at home, but this is page 2. This is the manslaughter page, and there are, there's not guilty of manslaughter while operating a motor vehicle under the influence. Then there's not guilty. And then there are lesser charges. And one of the charges, so this is question 2, number 5. That question is whether or not she's guilty of being under the influence. And the question was, can you find her guilty of that without finding her guilty of manslaughter? Isn't that what it sounds like they're asking? Okay?
The subcharge,
so
they called it.
The example that they used was the example about operating under the influence, which also lines up with their other question, which is about operating under the influence. So if you put those two together, it makes it really sound like that's what they're focusing in on. And just to give you a programming note, in a moment we're going to leave you here on Channel 4, and we're going to come back at about 11:25 to read more about the questions and hear the feedback from the attorneys. But we will continue this live on CBSN Boston, of course, streaming Pluto TV, our website, CBSN Boston as well.
Right. And then the other question was about the video clips of her interviews. Cheryl, they asked, are the video clips of the interviews evidence, and how should we consider them? So clearly what she said in those interviews after the fact is impacting their thinking.
Right. So they want to know, first of all, is it evidence? Yes, it is evidence. It was admitted into evidence during the course of the trial. It was used both during the trial and in the summation, as you might remember. And also, they can use it in any way they wish. They can use it to consider whether or not she's telling the truth, whether or not they're assessing her credibility, whether or not that has humanized her, whether or not they thought that she did not seem upset about what happened to to her boyfriend. They can use it in any way they wish to assess her credibility and character.
And it's interesting because obviously there was a lot said in those video clips that were presented in court, but one of the ones that they played was her talking about drinking that night, how much she had to drink, whether or not it was the number that the prosecution had said. There was a lot on that topic. So now you have 3 questions, and again, not jumping ahead, but all of them may pertain to the same thing. And if this means that on the second full day of deliberations at 11 o'clock in the morning, they seem to be focusing in on whether she was under the influence, that says really a lot about where this trial may be going.
She also, in those interviews, which it's very interesting, typically we don't hear a defendant do interviews, between 2 trials like this. She said things to the interviewer such as, could I have clipped him? Could I have hit him? She's asking those questions herself. So it's interesting that the jury would go back and say, how much weight should those interviews be given as evidence here?
It is all interesting. So we don't know at this point whether or not these are the only questions they have. These are the questions that they've given the judge at this point, whether they will have other questions in addition to these questions. But it certainly seems at this point the drunk driving part of the case seems to be what they're focusing on. We have to remember that for her to be found guilty on, the serious charges here, all the charges basically, is that they have to find that there was a collision, then that she did hit him. And so if they're not focused on that, and they are focused on, if that is in fact what's happening, and we don't know, then they are focusing in on the drunk driving part. They may find that she was drunk, she was driving, and she was drunk, and she was over the legal limit, but she did not hit him. Or they might find that, okay, once we find that she was drunk, can we go back up to the other charges and take another look at those? So it's going to be hard to tell. We
should add here, too, the judge said she was giving the attorneys about 20 minutes. She is taking this recess, and then when she comes back at about 11:15 or 11:25, then she will bring the jury in and convene and let the defense and prosecution.
So can I ask a question on that, Cheryl? So she wants them the prosecution and the defense, to take this time to go think about how they feel about these questions. There has to be an answer given back to the jurors.
Right.
I would guess that the official answer to these questions comes from the judge. So what is she now looking for from the prosecution and defense? Does she just want to hear what their thoughts are before she makes up her mind about what the answer is?
Yes. So they get to weigh in on this, right? They get to say, some of the questions are basically easy, like she just said. Obviously, you can the
evidence one's easy.
The evidence one is easy.
Yep.
The other one, obviously they have to show that if she's going to be found guilty of any of these charges, that she was driving drunk at the time that she was actually driving, which would have been the 12:45 time period. So, but I think that the question's legitimate, right? Because they say, okay, well, we have the blood evidence, and that was taken at 5 in the morning, so are we supposed to believe that that was when she was driving drunk, or was she driving drunk earlier? So I think that's a legitimate question.
Like, which number can they use? Can they use the one from the blood test, or can they actually do what the prosecution did, which was to sort of say, if it was this at that time, then it was much higher earlier. And they even went out of their way in the closing arguments to say, when she went home, do you really think she kept drinking? In other words, the number that you see was the number when she was driving.
Right. So I think that that's kind of where they're going with that. And then the other one, as I said, it's kind of hard for us to kind of interpret what they mean by saying, okay, by example, we're on the number 5, which is, the subset of the manslaughter charge. And to find her guilty under this charge, does that mean we find her guilty of the whole thing? And I think it is confusing. I mean, if you take a look at the verdict
slip is confusing.
It is.
And we should say, she clearly looked visibly upset at the end of the day yesterday when the judge rejected their motion to amend or change this form. But it's important to point out that the Supreme Judicial Court has approved this form. This is not something that can just willy-nilly be changed by a judge on one case or another, because then that would become an issue on appeal, correct?
Well, it still could become an issue on appeal. Look, if she's found guilty, they're going to say what they're doing during this entire trial, in addition to trying the case, is they're preserving the record and they're preserving their rights. So you have to object. You have to bring these motions. You have to say, we don't think this is fair. We think that you need to do this. So when she doesn't do it, you have something to go up on appeal and say to the appeals court, we asked for this and she didn't do it. And then the appeals court might find, well, This should have been
This is the
included.
approved form.
But that doesn't mean that it can't change. It doesn't mean that the court can't decide this was the approved form, but under these circumstances, or now we should amend it because we've seen that this has become an issue. So nothing is really that cut and dry when it comes to the law,
Yeah.
unfortunately.
And you make a good point, just like in life, if you object to something, somebody might say to you, well, why didn't you say something earlier? Well, they're saying it now. They're saying that this slip is confusing. And I have to say, just looking at it, I wish we could pop it up on the screen, but it gives you the guilty or not guilty on this manslaughter while operating under a motor vehicle influence of liquor. And then there are these subcharges. And what they seem to be wondering is whether or not you can give the subcharge without also giving the manslaughter. In other words, can you just say at the end of this trial, we find her guilty of operating under the influence? Nothing else. That kind of sounds like what they're asking if the example they're using is the example that they're actually interested in, which would seem odd that they would pick an example of something that they weren't actually interested in.
You would think. You would think. I mean, it's hard for us to say because we don't really know what they're thinking and how. And sometimes, the way the question comes out might not how it's being interpreted may not be exactly what they're looking for information. I mean, if you take a look at this, especially as you said, the manslaughter charge, there are all these 5 other, these sub-charges here to go through. And I think it's reasonable to say, okay, but if we think if we think she was drunk driving, does that necessarily mean that she's guilty up here of the manslaughter? So I think it's really going to come down to the interpretation. So that's what the lawyers are discussing and saying, well, if you're going to respond, we would like you to respond and say no. Each one of these you have to go, and she said that basically that they have to go down the line here. Whether they're doing it that way or whether they understand how to do it that way. I mean, these are lay people. They're not lawyers.
Right. So here are the charges. And so they're looking at a murder in the second degree, manslaughter while operating under the influence of alcohol, which appears to be what they're focusing in on in these questions, and leaving the scene of a person with an injury, in case of injury or death. But as you say, David, this is a dense form.
It is.
And there are all of these, the way the subcharges are worded is extremely complex. And you can understand why a juror would say, if I just want to focus on one aspect of this, is it all or nothing?
And it's like people have described it, Cheryl, as almost like a menu that's been put in front of them. And they have to make some choices. And I'm probably going to say the dumbest thing ever right now, but in this case, it's like, can I get just the side dish without the main dish? Do you know? And it sort of feels like that's the type of question they're asking. And just to go even further, because I think we've all made it crystal clear, we don't know what they're thinking. We really don't. We're just trying to analyze the facts that have been put in front of us. I was looking down at my phone a moment ago because Christina Rex is in the courtroom, and something that she wrote just before we came on the air was that her team huddled together quickly. They said something to Karen's family. One of them said, God, and they seemed relieved. Then when they huddled, Cheryl, it almost looked like there was some energy there, wasn't there? She was suddenly talking a lot, quite animated, which makes you wonder: are they really like, okay, now we're getting a sense of we're close here? I
mean, this could be interpreted as they took a look at the second-degree murder charge, and said it's a not guilty, right?
We're going to the next page.
We're going to the next page, and then they came all the way down to the end of the next page, and the charge that is the least concerning is the lesser included charge of operating under the influence out of all of these, out of the manslaughter charges, which all have mandatory sentences. This one does not have a mandatory sentence. So they could be at that point where they went through this, they went through all the way here, now we're here. And for the defense team, if that's the interpretation, that would be a good sign for them.
And what's the one thing that she did admit on those videotapes? What's the one thing she admitted?
She admitted she was drinking.
The one thing she admitted on there. And then they asked, well, how do we use that evidence?
Right. Let's talk about those interviews, Cheryl, because typically, I think in most cases, most attorneys ask their client to not speak, not talk to anybody. She chose to in this case. What was your reaction when you saw those interviews? And now that the jury is asking, well, they seem to want to confirm it is evidence, which it is, the judge said. How do we consider them? So they're wondering, how much weight do I give?
Yeah, that was an interesting phrase. How do we consider them? What does that mean?
How do we consider them? So as you pointed out, David, she admits to heavy drinking. on both of their parts, she and John O'Keefe, that night. She also asks some questions herself about her confusion about what may or may not have happened, which might, you know, and again, David has pointed it out. We're just trying to get here to the kind of conjecture the jurors are thinking about. They might be considering how confused or confident is she about what happened.
You know, they could consider whatever they wish. They can, you know, it's kind of interesting. They got to hear her voice because she did not speak in the courtroom. It's the only time that they actually got to hear her voice. She did not testify. She's given numerous interviews. You know, they can assess her demeanor. They can assess does she come across as someone who is confident? Does she come across as someone who's being truthful? They could consider anything. But it cuts both ways. I mean, they could also be looking at it and saying, you know, I don't believe her. You know, I think she was drinking, and, you know, this is my interpretation of watching her doing this interview. This is what I believe. I mean, everyone has their own opinion, and we know there are very strong ones in this case on both sides.
And when they say, how do we consider that piece of evidence where there are video clips, like you said, maybe the question is, are we only allowed to use the exact words that she said? Are we allowed to say, oh, we didn't believe those words, right? Like, what are we supposed to do with this piece of video? Do we take it at face value, or do we take it as how we sort of understand it as we watch it?
Right, and if you think about it, because she did not testify in either trial, as you point out, it's the only time they've heard her voice. She's not under oath, and she's not being questioned by anyone else. So they just have to interpret the way she saw and remembered the scene that night.
And, you know, she's defending herself, so she has the right to do that as a defendant. And there's a gag order in this case for both sides. The lawyers have not been able to talk, and it's her only way to get her story out there. And she has done, you know, she's done that in a very big way, doing all these interviews and even talking outside court pretty much every day.
You're a lawyer, but for a moment, we're going to make you a judge.
Okay.
All right, you ready for that?
Sure.
Now that we've analyzed why they may be asking, see if you can give us the answer to what the correct response will be. So they're asking, can they say she's guilty, as their example, guilty of question 2, number 5, which is, can she be guilty of operating under the influence of liquor without giving the overall guilty in that question, which would be manslaughter?
Yes.
The answer is yes.
The answer is
so
yes.
that's what you think we'll hear the judge say.
That
yes, you can say that she was operating under the influence without saying that it was manslaughter.
Right. And that's what, so they're called lesser included, right?
Yeah.
So this is a lesser included charge of the big charge. And so if you just say, I believe she was drinking and I believe she was driving, and that might be all they believe. They might believe that there was no collision, and that they believe that that part of the defense, whether they believe anything else that the defense said, we don't know, or whether they believe that there was no collision and we do believe she was drinking. There's all this video of them. They see her at the bar several times drinking all the drinks. She admits to drinking the drinks, and maybe that's all they find her guilty
The
of.
word included would throw me off, though, because that's what makes it sound like the two are attached. One goes with the other.
Right. It's a lesser included.
Yeah.
Lesser included charge.
Right.
Back to, so your answer to that from a judge would be yes. The judge already said yes, the interviews are evidence.
Yes.
And you said the time frame for the OUI charge has to be 12:45.
Right. That's what they're, I mean, that seems to be what they're looking for, those types of answers. So it'll be interesting to see what the defense says they need to say about these charges, what the prosecution wants the judge to say. I'm sure that they have their own thoughts on how they want her to make the statement. You know, they also have the law to consider when they're going through all of these charges. So, you know, there's a lot here, but I do think it's super interesting that they've asked for that specific question.
And the first time around, as Paula said earlier, I think it was on the same day, the second full day of deliberations, that they had a question. But their question in the last trial was really about the search for evidence, what they found on the scene, which really gave the picture of a jury that was still very much in the early stages of figuring out what happened there at the scene. This seems to be the exact opposite. They're already as far ahead as looking at the charges, unless They just want to know what they can do with the charges
Right.
before they really dive in and start answering some questions, because that's possible too.
It is possible, and they could just have gone through this and said, okay, we understand what this first charge means, and we're not taking a vote. And on this one, the only one that we have some questions on is this last one here.
Except they spent
So-
a whole day yesterday also deliberating, right?
They did, and they
So-
spent a couple of hours on Friday
Yeah.
deliberating. We think they're deliberating. I mean, you know, it could be that they got in there and they said, you know, we want to just go, everyone wants to take a look at the evidence and review the evidence. And in terms of not voting, we're not voting on anything. We just want to be able to talk about this, take a look at the evidence, see what other people think about the charges, get everyone's view so everyone feels like they have a voice and they're participating in the process. I mean, there's really no way to know what goes on in those jury rooms.
Right. In terms of Judge Beverly Cannoni, we're just a minute or so away from court coming back into session. What is she allowed to say when she answers jurors' questions? Does she just go through each one of them and simply give the answer? She doesn't obviously want to lead them in any particular direction, right?
Right, but I mean, first she'll get whatever the lawyers have to
Yeah.
say. She's going to let them have their say about what they think.
Before
about
the
these
jurors come in the
questions.
room.
Before they come in the room.
I see.
She'll let them have their say. That will all be part of what she does. And then once they make whatever decision she makes based on those conversations, she will have the jury come back in and she will answer their questions.
All right, so there's a
That's it.
possibility that they come in and they talk and that she takes another quick break? Or do you think she'll be ready to call them in?
She should be ready to call them in, but
Okay.
she could, if they bring up any case law or anything that she feels like she needs to take another break to review herself before she makes a decision, she could definitely do that.
And if you're the defense, your answer to this is absolutely you can vote just for operating under the influence,
Yes.
right? I mean,
Yes, that's right. Yeah, I mean, it's going to, like I said, it's really hard to tell exactly where they are. I mean, you know, that's what we're just interpreting based on, you know, what we believe these questions represent. We don't know that this is what that represents, you know, in the big scheme of their deliberation.
except we've never been wrong before, sure.
No, I know.
So right here we have all of the parties and the judges back in the courtroom, jurors not there, not live as of yet. We know they're back. They're just waiting for the judge to re-enter the courtroom before we get back underway. She had said she was going to begin again at 11:25. I'm just taking a few more minutes.
And sorry, I keep popping up on my phone here because I just want to see
Yeah.
what Christina Rex is seeing inside. A minute ago, she did say all parties and families are back in court waiting on the judge. The notes came back on 3 yellow note cards, and the judge herself, and the judge is entering now.
Let's go back to the courtroom.
This is breaking news from WBZ.
This is a WBZ special report. We are going to the courthouse in Dedham. Judge Beverly Cannoni begins answering jurors' questions.
The first question, the time of the OUI. Any suggestions?
Your Honor, do you want to hear from the defense first?
I'll hear from you're standing up, so I'll hear from you first.
Okay. On question number 1, what is the time frame for the OUI charge, offense 002, section 5, OUI at 12:45 or OUI at 5 a.m.? Our suggestion would be something along the lines of, ladies and gentlemen of the jury, you have the evidence. It's your decision.
You are the fact finder.
You're the fact finder.
Mr. Brennan, or whomever from the Commonwealth?
My suggestion would be 12:45.
And why is that?
The case has always been focused at that time. I don't think there's anything specific in the indictment regarding the time.
Do we have the indictments?
No.
I do want.
The indictments.
If it's not in the indictment, I'm uncomfortable telling them a time.
I'm sorry?
If it's not in the indictment, I'm uncomfortable telling them a time.
Understood.
All right.
I agree with the court on principle. I just don't have the indictment memorized, so I don't remember. If we can pull that up.
There's no time? I don't expect that there's any time to be.
All right, so I'll say you have the evidence, and remember, you are the fact finders, or something to that effect. All right. Are the video clips of Karen's interviews evidence? How can we consider them? So I'll tell you what I was planning on saying, then you can add to it.
Sure.
Yes, the videos are evidence. Give them whatever weight you think is appropriate to give them, and then I would give the digital evidence instruction and the humane practice instruction.
The only thing I would respectfully ask the court to include in that sentence is give them whatever weight, if any, you deem appropriate.
All right.
If any.
Okay.
Thank you. Otherwise, it's fine.
Okay. What's the Commonwealth's position?
We have a different perspective on that.
Okay.
The first part of the question, are the video clips of Karen's interviews evidence? The answer should be yes.
Okay.
How can we consider them? I think it's fair to say you should weigh the defendant's statements as you would evidence. Since they've been introduced substantively, they are like any other piece of evidence. There's no difference, and there shouldn't be any reflection of a difference in the answer. We didn't introduce any evidence in this case and say you should give it any weight, if any at all. We didn't provide a limiting instruction in any way, and these shouldn't be so limited. This is just like a photograph. It's no different than a physical piece of evidence. And so I think the answer should simply be yes. You should weigh the defendant's statements as you would any other piece of evidence. I do not think the court should give humane practice or digital evidence. It suggests that there's some deterioration or further analysis that is different. Those instructions were already given during the charge. In addition, those instructions are in their hand in the written jury instructions. And so, to put it most simply, as I think that we should, is this is a piece of evidence, and you weigh it like you would any other piece of evidence, whatever they decide, rather than give them guidance to curtail it or to limit it in any fashion.
My only suggestion, Your Honor, is that every single piece of evidence that's provided to them, it's in keeping with Massachusetts laws, in keeping with the responsibility that they have. Every single evidence is given the weight, if any, they deem appropriate. That is not a misapplication of the law. I think the Commonwealth's suggestion suggests in the answer that they should or they have to give those statements weight, and the law is they don't have to give them any weight. So I think the appropriate comment by the court is exactly as the court suggested initially, which is you give it whatever weight, if any, you deem appropriate.
I want to jump back
All
in
right.
now, actually. Let me
So
get
what
back
I'm
off
going
so we
to
can
say
listen the
is,
judge.
yes, the videos are evidence. You should weigh the defendant's statements as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, then I'll go and I'll read the electronic communications and the humane practice. That covers it.
I don't have a principled objection to it if the court adds the word "if any,"
I understand.
because I don't want them to think, for instance, the way that it's worded as the Commonwealth suggested it, they have to weigh it the same way they weigh other pieces of evidence. Every single piece of evidence is weighed in and of itself. It's individual to the piece of evidence that's presented. For instance, they could weigh the statements by Ms. Reed. They could give it no weight. Each individual juror could decide, I'm going to dispatch it altogether and give it no weight, while giving another piece of evidence, like whatever that might be, the testimony of one of the ARCA witnesses, complete weight. I think that we need to stress that the clips bear no additional weight, no additional gravity than anything else that they've considered. And the only way to do that is, very simply, you give this the weight, if any, that you decide is appropriate. It doesn't, I think, comparing it and contrasting to other pieces of evidence in the case, it's unnecessary, and it tends to suggest they have to give it weight.
Okay. So your objection's noted. Now let's get to the third one. Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What do you want to say, Mr. Jackson?
Your Honor, I appreciate the effort that the court went to amend the verdict slip as it relates to count 2, and I think there are some excellent suggestions by the court in the verdict slip. By and large, I think question number 3 is answered by the amendments in the verdict slip. So we certainly could say something like, does convicting guilty, the question was, quote, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? The answer is no, obviously. And perhaps we could formulate an answer that says something along the lines of, no, new verdict slips have been provided that will make it more clear, or something of that nature. As well as a decision of guilty on the OUI charge 002, number 5, is an explicit acquittal on the higher charges in offense 002, which is a proper statement of the law. And then there are suggestions that we have regarding the edits that the court has made to the verdict slip. And I'm happy to go over those with you and put those on the record.
Okay, go ahead.
With regard to going from the top to the bottom, just under number 1, number 1 reads, not guilty of the offense charged or any lesser included offense. We would propose
All right, we've frozen here.
comma, stop, and sign the verdict slip, period. That's the only place that that language doesn't appear, and I think it should appear.
Okay.
The second is a relatively minor issue. However, under number 2, sub 2, the parenthetical check one or both of the following, I think it should say, just to clarify it further, if guilty, comma, check one or both of the following.
All right, I think I'm going to leave it because it appears only under the guilty.
It appears only on...
Under the guilty. So go ahead. I'll hear you further.
Going further, going under number 3, toward the bottom of the page, in the parenthetical that the court suggested, which we find is excellent, if you find the defendant guilty of the lesser offense of involuntary manslaughter, we would simply add that clause.
So we'd have to add it in all of them.
Correct.
Which makes sense. I think
Correct.
we had it in the first one.
Right.
Okay.
And then moving to page 2, at the top of the page under sub 4, again.
Hold on one second.
Of course.
Okay.
We had the same suggestion. It appears that the court is not inclined to give it. If guilty, check one or both of the following. And there's a typo. It says the parenthetical
We fixed
says,
it.
Check one of. Okay.
Yes, so we changed of to or.
So my only suggestion to that would be to, again, add the if guilty, comma, check one or both of the following.
Okay.
On that page, going down to the bolded parenthetical, same thing. If you find the defendant guilty of the lesser offense of motor vehicle homicide.
Okay.
Moving down under sub 5, the
We still
OUI.
need to say stop and sign the verdict slip.
Right. After the word stop and sign the verdict slip.
Yeah.
And then under sub 5, again, the same thing. We just suggested that for consistency that it say, if guilty, check one of the following of the both. And the final edit would be in the final parenthetical, the last sentence. If you find, I think her should be
Yeah.
changed to the defendant.
Sure.
If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1.
Okay.
And those are the edits that we have suggested for the verdict
All
slip.
right. Mr. Brennan?
I don't have any disagreement with the edits.
Okay.
The idea of instructing them on the nuance of selecting one guilty or not guilty, I don't think needs to be explained. I think with the edits, this proposed instruction explains it. Yes.
All right. Would
I don't have any issue with if you state, if you decide on a lesser included offense, it does not include the earlier offense. And I'm not sure of the exact language that can be used. I don't think that's necessary, but that is something I wouldn't have an objection to. But I think the form that you filled it out with the edits is going to be sufficient for them to follow.
What do you think about the defendant's position that if you were to find her guilty of operating under the influence, Mr. Jackson said explicit acquittal. I don't like that language. I think if you find it means you have found her not guilty of each of the others.
That would be fine with us.
I think it's better if you find her guilty of any lesser included offense. It would not include the higher offense.
All right.
I think that's just confusing.
So what I planned on doing was bringing them out and giving them each a copy of the amended verdict slip, explaining that it really is consistent with the jury instructions I gave them, but walking them through it. So we start from the top and then explain if you find the defendant guilty, you're done. Stop, sign the verdict slip, and let the court officer know you have a verdict or something.
I prefer that.
I think I'll walk them through it like we do in civil cases.
I don't have any objection to that. The only other thing is the digital instruction.
Yes.
We don't believe that it's necessary. I don't think that we should reemphasize that, and we're not asking for it.
All right, so you're waiving it?
We're waiving it.
Okay.
Yes, thank
All right,
you.
I will do humane instruction, humane practice instruction. So I need 5 minutes, and Tori, your computer, to amend this if we can, and we'll make copies. So we'll bring the jurors in. Let them know that we'll be bringing them in shortly, Tony. All right, thank you.
All right, so this is Paula Eben along with David Wade and Cheryl Fiandaca on WBZ as we wait for the judge as she takes a few minutes. What's your initial reaction to all of those exchanges, Cheryl?
You know, I'm not surprised. I mean, you know, she basically says the jury is the fact finder. It is. You know, for the prosecution, they want her to have been drunk driving at 12:45. Of course, the defense is like, we don't care at 5 a.m. She didn't kill anybody. There was no accident at 5 in the morning. It doesn't matter. That's when her blood was drawn. So they can decide whatever they wish about that.
So just the background on that, they asked, when it comes to the OUI charge, do we consider 12:45 at night, which is when the alleged incident happened, or at 5 in the morning when the blood was taken? And they basically agreed to say to the jury, you have the evidence, you are the fact finders.
And the judge said it was not specifically put in the indictment, so she wasn't comfortable giving a time.
Right. So and that's up to them. They can decide it's 12:45, which benefits the prosecution. They can decide it's 5 a.m., which obviously would benefit her.
Okay.
So, and then
Video evidence.
The video evidence. And I think there was like a little bit of a sticking point there, but the video evidence is the evidence of all the interviews that she did. And you would give it any weight you would give any of the other evidence. And I think that the defense wanted to say, if you give it any weight at all, thinking that anything that she may have said was not helpful to them, if that's what they believe. Whether they are using it to assess her credibility, as I said, or whether it is, in fact, she did talk about the fact that she had several drinks. Maybe that does go back to that, and so they're piecing all of the drunk driving and the drinking together. We don't know.
And it's interesting because the defense wanted that phrase that you just mentioned, give it any weight that you deem appropriate, if any. The prosecution that stepped forward and said, whoa, 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 whoa. With all of the evidence in the case, you're allowed to give it all weight or no weight, and nowhere else have we told them that about a piece of evidence. And it sounded like the judge sort of agreed just to leave it as simple as give it any weight you deem appropriate.
It's like a photograph or anything else that's been entered as evidence.
Evidence is also testimony. It's what people say. So it's the expert that testified to, the taillight. Whether you believe that person, you give them the weight or not, whatever you wish, whatever your interpretation is of their testimony.
And then finally, on the third question, which they seem confused, does a guilty on a subcharge convict on the overall charge?
Right.
Let's talk about the edits to the verdict slip.
I think we can pop this up on the screen. Our producer said that we have a copy of the verdict slip. If we can use page 2 to put up there the manslaughter charge. I know that that's a tough ask right away, but if we can do that. And Cheryl, go ahead and with Paula's question.
Right. So basically, what the judge told them to do is just start going down the list of of manslaughter and the lesser included charges. So you can see it there. You can see there's a lot to consider. So first off, it's just you look at it and says, is she not guilty of the offenses charged or any lesser included offenses? So that is supposed to signal to the jury the lesser included offenses are separate. So if you say she's not guilty of manslaughter, but she could be guilty of a lesser included charge of involuntary manslaughter. But the fact that they're down to the last number, which is 5, as you can see here on the screen, the lesser included offense here is operating under the influence of liquor. And that's all it is. It doesn't include any type of collision, any kind of death, any kind of injury. It doesn't include any homicide, manslaughter charge, nothing like that.
And in terms of tone, we should say Karen Reed was smiling there. She appeared relieved by what these questions focused in on.
Right, but as we've been saying all along, though, that does not necessarily mean that that's all they're focused on. There may be some other things that they are focused on, and some of it could end up being inconsistent with what the judge tells them, what the law is, and what the deliberations will continue to be.
And what's interesting is that, on Friday when they had the closing arguments, both sides sort of whittled their entire argument down to like a couple of just quick sentences. And for the prosecution, it was, she was drunk, she hit him, she left him to die. They said that several times. For the defense, it was, there was no collision, there is no case, pretty much what are we doing here? There was no collision, they said that over and over again. The only charge on here that has anything to do with not being a collision is this one. All this charge says is that she was driving under the influence, if that's what they decide. It does not say there was any collision at all. Manslaughter means there would have been some type of collision, right? Murder, there would have been some type of collision. Even leaving the scene of something where there was death or injury, there would have been a collision. So it seems like they're really focusing in on something. If we're believing the tea leaves in the right way or reading them the right way, they are sort of focusing in on the one thing that does not involve a collision, which is exactly what the defense wanted.
It is, right. And at this point, as we, it appears that that's where they are in the deliberations. We don't know that for a fact, but it certainly seems that they are super focused on the drunk driving and the drinking and her whatever she said during these interviews that she gave, to television stations and to documentaries, and that's where they're putting most of their energy. And we know what the blood alcohol level was.
And as you pointed out before, since she did not testify in the trial, that's the only time they heard from her, heard her voice talking about the activity of that night and the level of drinking. So that's the only thing they know coming straight from the defendant's mouth.
And that's interesting, right? I mean, you know, she's given all of these other interviews, but she did not take the stand. She was not subject to cross-examination. You know, she didn't answer individual questions that were presented to her. She got to answer interview questions in an edited form that was later presented to the jury. And so they could, as the judge said, they can give that evidence whatever weight they wish.
And what's interesting in this case is that when you talk to people, and we've all said the same thing, people approach us all the time to ask us what we might know extra about the case. When you talk to people, they're all super passionate. Right? A lot of people have made up their mind a long time ago. The people who haven't made up their mind on this case tend to say, I don't know what to believe. I don't know what has been proven. I just don't know. And so when you go back to the videotape and you go back to this idea of OUI, it's sort of the one thing you do know.
Right.
You do know she was drinking. She said it herself in that video. So the question would become whether the jury is sort of 12 of the people out there who just don't know overall what to believe. And so maybe they have to lean in on what they do know. Again, complete taking a guess here, right? We're just trying to analyze the facts in front of us, which is what we do. And maybe that feel is there.
David, I think that that's exactly what they're doing. I mean, they're looking at it and saying, okay, there's all this extraneous information, right? I mean, what the prosecution has put out for their case and trying to explain that she did hit him and the tail light and how they collected the evidence. And, you know, that's what they believe happened in this case. And then you have the defense who has been putting forth this conspiracy theory that this was a conspiracy with law enforcement and that there were alternative suspects maybe involved. But at the end of the day, there was no collision. So she never hit him, and she never left him to die in the snow. The only thing that they could hang their hat on, they heard her say that she did drink, that she did have several cocktails. There's video of her drinking and seeing her in these, you know, establishments. And there's the blood alcohol. So those numbers, they can say, okay, we believe this. The rest of it might just be, as you said, you know, they're taking a look at it and saying, I just don't know.
And then asking the question, was it 12:45 or 5 a.m.? It's going even further to say, are we able to say that, you know, that she was under the influence and not just drinking, based on the evidence that we have in front of us?
Right. Right, and you know, it's individual. Every person is going to think something different. So it's not, you know, everyone that you talk to about this case has very definite opinions, and or, as you said, has said, you know, there's just so much information out there, I don't know what to believe. And if you don't know what to believe, and the jury is in that position, and if that's where they are, then you have to say not guilty, because it's beyond a reasonable doubt. And if you're not convinced beyond a reasonable doubt that she, in fact, hit him while under the influence or intentionally did it, and left him to die, then you have to vote not guilty. If you believe that, okay, we think she was drinking, we think she may have been drinking and driving, but the rest of it, I'm not convinced.
But the wording that the judge will use very specifically has now been agreed upon by the defense and the Commonwealth. Interesting on that third conversation about the verdict slips, the Commonwealth had no issue with the edits, with the language that was going to be used. But for any viewers that might be just joining us now, as we approach the noon hour, there were 3 questions from the jury this morning. One about the time frame for the OUI charge, one about the video clips of the interviews, whether or not they were evidence and how they should be considered. And then third, would a guilty decision on a subcharge convict on the overall charge? And as Cheryl and David and I have been discussing, the 2 main questions focus in on the OUI charge in this case so far. These are the only questions the jurors have had so far in this trial.
That we're aware of at this point in their deliberation. Right. So it seems like, you know, they seem to at least be focused on page 2, focused on the manslaughter charge within the lesser included charge of operating under the influence. And it seems that that's where most of their questions are coming from at this time.
And if there's one thing that the defense, even right now, before we know anything else, can really stand up and say, we were right about this, it's perhaps that this is confusing.
That the verdict slip was
Right? They've
Right.
said it's confusing. The judge has said, hey, this is what we have. This is what, do you have any case law to say that it's not okay? And they said, not right now. But I think we are learning that this is a confusing verdict slip for a lot of people.
Right, and just the idea of you calling something a lesser included. So I think when you and that's what the charge is. It's a lesser included. All of these other charges that are part of the manslaughter, operating under the influence. So I think when you say lesser included, some people will think, okay, so that means that if I find her guilty of this, I have to find her guilty of this because it's included in that charge.
in the overall charge.
Right, but that's not exactly what this means. This means that these are lesser charges that are included in the larger charge. But they're separate.
Yeah,
It's like an
not-
SAT question.
Yeah, it's not like
Right.
it's not like there's a page 4 that just says, is she guilty of operating under the influence? It's all on the same page as the manslaughter,
Right.
which makes you think that they have to go hand in hand. And the judge is going to
Right.
tell them that they don't.
Right.
And what you're going to see when they come back into the courtroom, it sounds like the judge is not just going to give a quick synopsis answer to each one, because she did say she's going to sort of walk them through this whole thing.
Well, she's also going to read them some instructions that she had, some of which she's already given, to kind of help them focus on what the law is that they have to apply to the evidence in the case. And hopefully that will. Sometimes it helps, and sometimes it's even more confusing. But sometimes it's just getting the answer to the question that they can say, you give it whatever weight you want, and the instruction that goes along with that, maybe they need it, maybe they don't, maybe that's the only thing they needed to know.
So what's happening right now, we're waiting for the judge to return. She was gathering her thoughts. The jury is not in the courtroom. The judge just conferred with the attorneys for both sides. She's taking a few moments to gather her thoughts, get exactly the wording of what she's going to say to the jury about these 3 questions and their instructions. And so we're awaiting her return to the bench, and then they'll bring the jury in.
And just one quick thing, if we can, at some point, talking directly to our control room now, there was that piece of video when the question first came back, and Karen Reed's defense team and Karen all gathered together and very animated. Talking about the question that came in. We'll have that at some point. And you could see how animated she got. And that was
relieved.
right around the time that Christina Rex tweeted out that she said something to her family, or her defense team did, and that they seemed relieved. One of them saying, God, out loud. So again, just putting together pieces of evidence to see if they add up to some type of answer that we've been waiting, 9-10 weeks for now. But yeah, I found that to be a really interesting moment, because it was the first time in a long time where you saw just all of a sudden, okay, something's moving here. And from the way they acted, they seemed to be somewhat energized by it.
Right, they're interpreting this as a good sign.
Yeah.
They're interpreting this as, okay, if we're only looking at the OUI charge, this is a good thing. We're not looking at the murder charge, we're not looking at the manslaughter charge, both of which, carry heavy mandatory sentences. So of all the things in this picture of this case, this is the least concerning for them.
Yep.
So that would be good news for the defense at this point.
Very, very interesting. It is interesting that the jury, have to specifically ask if the video clips of the interviews were evidence. I thought that was an interesting question. They asked how to consider them, but perhaps because it was after the event, right? We don't know what's in their minds, but they did have a very specific question about those interviews that Karen Reed did.
Well, I think a lot of people, when you think about evidence, most people think it's like a physical thing,
Yeah.
right?
Right.
So it's a phone, it's a video,
Piece of clothing.
it's a piece of clothing.
Right.
But that's in a trial. That's not the only evidence. The evidence is testimony, and the testimony that was given by the witnesses. And there's also during the course of the trial, and it's also part of the procedure that lawyers have to follow. You have to authenticate what you have that you want the jury to see, or the judge if it's a judge trial, a bench trial. And then you have to enter it into evidence. There's a specific way that you have to do that. And this evidence of her speaking on, to reporters and interviews, that was entered into evidence. So it then becomes evidence. And they can give it whatever weight they wish, the same weight that they would give any physical evidence, whether they, believe the videos that they see, whether they believe the photos that they see, whether they believe any of the witnesses that are testifying. They can decide what they want to do with any of that.
So when the jury comes back, she will read back their questions, the agreed upon language to explain each of them. But you also said that she will be going through the edits to the verdict slip and some more jury instructions, which unfortunately can be very confusing at times. You are watching WBZ News at noon. This is a special report. Paula Eben here with David Wade and Cheryl Fiadaco. We are waiting for Judge Beverly Cannoni to come back into the courtroom because the Karen Reed retrial jury had 3 questions this morning.
3 questions, so to boil them down quickly, if you're just joining us, and if you've been watching us on the stream, you've heard this. The first question was the time frame for the OUI charge, which was one of the lesser included charges to the manslaughter charge, because the manslaughter was manslaughter while under the influence of alcohol. They wanted to know, do you use the blood alcohol level at 12:45, which is what the prosecution sort of had to lead them down the road of what it might be, because the blood test was actually taken at around 5 in the morning. So they wanted to know, is operating under the influence the 12:45 incident, if there was an incident with the car, or was it at 5 a.m.? So that was their first question. The second had to do with video evidence.
Right, and just wanted to say the judge said the times would not be stipulated because the initial indictment did not have those times listed, Cheryl, right?
Right, and so they can, they're the finders of fact. Obviously, the prosecution wants them to say that it was at 12:45 because that's when they believe the collision occurred, and the defense is like, well, she got her blood taken at 5 in the morning. And, maybe she could have gone home to have drinks between the time that she dropped him off and went home and had another glass of wine or something else to drink. No one knows.
The second question, at least in the order that the judge read them, was about whether the video clips of the interviews Karen Reed did is considered evidence and how to consider them.
And basically, they're going to come back and say, yes, they are evidence, and you should consider them the way you consider all other evidence in the trial.
Right.
The third question, and this is where things really get interesting, is they wanted to know, and they used as an example, page 2, subcharge 5. Page 2 is about the manslaughter charge. Subsection 5 is about operating under the influence of liquor. And what they basically asked is, can you say guilty on the OUI charge without saying guilty on the manslaughter charge? So that really gives us a sense of what they may be zeroing in on, and the judge will tell them what, Cheryl?
The judge is going to tell them that you can decide that charge, if you find her guilty on that charge, it does not mean that she is found guilty on the other charge. You have to go down the line according to what this verdict slip looks like. The interesting thing here, and this is an example that the jury gave in their question. They said, for example. So we are interpreting that to mean that that is the question that they want answered on this particular issue and on the manslaughter charge. We don't know it for a fact, but that's what they said in the note, for example. So we have to try not to read too much into that.
Well, as you said, this is reading tea leaves at this point because they haven't had any questions, which the Christina Rex pointed out during the first trial. The jury had a question on day 2 that we're now into day 3 of deliberations. And you said, Cheryl, you can't read the tea leaves. The atmosphere in the courtroom definitely changed when these 3 questions came in. And David, you were talking about what we observed.
We do have a piece of video, and we want to put this up. And what you're going to see is this is right after the questions came in. Karen Reed's defense team went up to talk to the judge. They came back to sit. This is not live. This is from a little bit earlier. And then all of a sudden, they all stood up together. And in a very animated fashion, you could see Karen Reed now talking to her lawyers about this. Christina Rex in the courtroom mentioned how someone said something to Karen Reed's family, and somebody said out loud, God, and then seemed very relieved by everything, which again made us believe that perhaps they're hearing that this focus is on OUI, and that's obviously one of the least concerning charge to them throughout this whole process. This is not the piece of video I'm talking about. in the piece of video I'm talking about, they were standing up at the time, and you could really see Karen animated. But she is here as well with, I think that's Robert Alessi, who's standing up, David Yannetti in the background there, as they were getting together what they may want to tell the judge about how they should answer these questions. But we haven't seen a lot of this, Cheryl, where she seems super animated, at least not for a while.
Very involved.
No, absolutely. We're seeing a lot of animation, and obviously there's a lot of conversation about what's happening and their interpretation of what these questions mean. It obviously appears that they are interpreting it as a positive sign for them. And the response that the judge will give to each of these questions, they also see as positive, even though they've asked her to tweak some of it. I think for the most part, her responses are pretty much in line with what they expected they might be.
We do have, I believe, we can go to Catherine Loftus, who is joining us also live. She has been our legal analyst throughout this retrial. And Catherine, if you can hear us, give us your thoughts.
I can.
Give us your thoughts about what you've heard here today and sort of where you think this might be going.
Well, I think it's certainly favorable questions to the defense. Obviously, we've been waiting for some time. We had Friday afternoon all day yesterday without questions. So I think there was likely going to be something that we heard from the jury today. You know, it's always difficult to know exactly where the jury is going and do we know exactly what they mean based on these questions. But I do think overall, specifically the question number 3 about convicting on the subcharge, count number 2, number 5, you know, theoretically, they could be using that as an example and aren't honing on that. But certainly, if we were to evaluate just on its face, I think these are favorable to the defense. This seems to be an indication that they are considering whether or not she was even guilty of operating under the influence. You know, the question about the video clips is a little bit more interesting. It's surprising to me, given sort of the amount and depth of video clips that we saw entered into evidence, why they would think that they couldn't consider them. So there may be some, you know, back and forth in the jury room about, you know, we can use her statements versus we can't use her statements. But overall, I think these questions are definitely more favorable to the defense.
I think you're right, Catherine. And this is Paula Eben, by the way. The connection between the 3 questions, it is interesting. After all this time, they would ask about the clips of the interviews as evidence. And the only thing I can think, since the other 2 questions were about the OUI charge, is that because she never testified, that's the only time they heard directly from Karen Reed, and she described the activities of that night. And we're going to interrupt just quickly because here is the judge. We want to go back to the courtroom. The parties and families are there, and here is Judge Beverly Cannone.
Do you have those? So Tony will take those. All right, so I'll take, thank you. Tori, how many did you make?
Okay, quick delay here, and we're going to hold off on going back to Catherine because I have a feeling the judge is going to speak up again in a moment. But again, she's going to bring the jurors back in and explain to them what the answers are, in her legal opinion, to their 3 questions.
The only thing I was going to mention there to Catherine is that the only thing about the video evidence is, since that was the only time they heard from Karen Reed talking about drinking that night, but she wasn't tested. She wasn't under cross-examination. They might have some question in their mind if they can give that equal weight to the charges and the evidence that were entered about the probability of OUI.
Well, I think, you know, as we talked about, you know, the understanding of what evidence is not as clear to a layperson as it is to a lawyer. So I think just making that clear that it's evidence like any other evidence. You give it whatever weight you wish.
Right.
And you interpret it however you would interpret any other type of evidence.
We have a tweet from Christina Rex moments ago saying that they're back in the courtroom, still no jury. So we do not believe at this point that the jury is back in the courtroom, so that's the delay that we're hearing right now. We're going to ask Catherine Loftus to come back in just with the amendment, Catherine, that we might pop back in and interrupt, so we apologize ahead of time. So just your thoughts on as we move forward here, what's happening. It doesn't sound like Catherine is there at the moment.
Maybe not. We're just probably waiting for the jury to be assembled and brought into the courtroom, and that
Yeah.
sometimes takes a couple of minutes when you have to just bring them from where they're deliberating.
All right, the court, please. Jury's entering. Court is back in session. You may be seated.
All right, jurors, we're in receipt of your question. We've been working on making sure that the answers we give you are the right ones, so it's taken us a while. So the first question, what is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The answer to that question is that you folks have all the evidence. And remember, it's only you who decide the facts in this case. All right? That's the answer to that question. You are the fact finders. The second question, are video clips of Karen's interviews evidence? How can we consider them? Yes, the videos are evidence. You should weigh the defendant's statements in the videos as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. So that's the answer to that question. So for the third question, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? So with that, what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip, and it's still consistent with the jury instructions I gave you, but it's a little bit easier for you to follow. And for purposes of going through this, we'll go through it together, and I've got a copy for each one of you, okay? All right, so you'll see it really is the same verdict slip, but we've added a little bit of language to help you follow it through. So the first charge, manslaughter while operating a motor vehicle under the influence of liquor. So first, in the above entitled case, we say the defendant is, 1, not guilty of the offense charged or any lesser included offense. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip. Now, then you go on to guilty of the offense of as charged, manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following: manslaughter while operating a motor vehicle under the influence of liquor and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip. That means on each one, when you stop and sign the verdict slip, that means you have a verdict on this indictment. So stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence of liquor, then continue below to the lesser included offense. And first, under 3 is involuntary manslaughter. If you find the defendant guilty of the lesser included offense of involuntary manslaughter, stop and sign the verdict slip. If you find her not guilty of involuntary manslaughter, then continue to the next page. Guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence. And you have to check one or both of the following. Motor vehicle homicide under the influence of liquor and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below to the guilty of the lesser included offense operating under the influence. And you check one or both of the following: operating a motor vehicle under the influence of liquor and or operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of operating a motor vehicle under the influence of liquor, then stop. If you find the defendant guilty, you stop and you sign the verdict slip. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1. And remember, your decision must be unanimous. All right, does that make it any clearer, hopefully? All right, so with that, I am going to send you back out.
Before the jurors are sent up, can you
Sure, why don't you come on over?
So clarifying the verdict slip was the last thing that we had heard, you know, in the case, and Karen Reed was very animated about that. And now we have had the jury come forward with these questions. Specifically, as David pointed out, they did appear confused.
You know, and that's why she gave them a new verdict slip that basically says, and she kind of did this during her instructions earlier, saying go step by step. And say, if it's not guilty of this offense and everything else below this, basically the lesser included, then sign the verdict slip. If you think...
I heard myself say this, and I'm glad counsel told me I did. So if you go back and look at the form after 4, if you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony, OUI, liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below. I think I said, then find, I don't know what I said. I heard myself read the guilty of the lesser included offense. So if you find her not guilty of motor vehicle homicide under the influence of liquor, then you continue to decide whether the Commonwealth has proven to you beyond a reasonable doubt that she's guilty of operating under the influence of liquor. And if they have not, and if you find the defendant not guilty on this offense and all other offenses, then you go back and check the first box. So you follow it from the top to the bottom in this manner. Okay? Thank you very much. We're going to release you.
All right.